attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a LawCast series talking about Form 8K. A public company with a class of securities registered under either Section 12 or which is subject to Section 15D of the Securities Exchange Act of 1934 must file reports with the SEC. Exchange Act Rule 13a-11 requires the filing of current reports on Form 8K. Subject to certain exceptions, a Form 8K must be filed within 4 business days after the occurrence of the event being disclosed. No extension is available for an 8K. Companies must file this report with the SEC to announce major or extraordinary events that shareholders should know about, including entry into material agreements and the issuances of unregistered securities. It is these 2 specific events that are implicated with the entry into corporate financing transactions and subsequent conversions of convertible instruments such as convertible debt or preferred stock. In particular, Item 1.01 of Form 8K requires that a company report if it has entered into a material definitive agreement not made in the ordinary course of business. Under Item 1.01, the company must report the date of the agreement, the parties to the agreement, a description of any material relationship between the parties other than the reported agreement, and a brief description of the terms and conditions of the agreement. Generally, a corporate finance transaction is an extraordinary agreement. Item 3.02 of Form 8K requires that a company report the unregistered sale of securities. Under Item 3.02, the company must report the unregistered sale of securities if the aggregate sales or issuances of securities constitutes 5% or more of the outstanding securities since the last reported number filed with the SEC. The report must disclose the date, title, and amount of the securities sold, the nature and amount of consideration paid, the Securities Act exemption being relied upon, and a brief explanation of the facts supporting that exemption, and, where applicable, the terms of conversion or exercise. The Item 3.02 filing requirement is triggered if the volume threshold of the underlying equity securities issuable upon conversion is exceeded, even if those issuances are structured as takedowns over time, such as where a convertible note is partially converted in multiple tranches. If it is foreseeable that the total number of securities issued in a corporate finance transaction or issuable in that corporate finance transaction will exceed 5% of the current outstanding securities, an Item 3.028K must be filed. Likewise, where the actual conversions and issuances of securities exceed the 5% threshold in aggregate, an 8K is required. The Item 3.028K must disclose all unregistered issuances that resulted in increasing the total outstanding securities by the 5% threshold. As a simple example, if a company reports 10 million shares of outstanding common stock in its 10Q, and then proceeds to issue 100,000 shares each in a series of conversions of a convertible debt. As soon as the total outstanding reaches 10,500,000, the 8K filing requirement would be triggered, and each of the conversions that led up to that 10,500,000 total outstanding would need to be reported. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.